Hello everyone. In today's video, we are going to cover the contempt jurisdiction of the Honorable Supreme Court. So when we study contempt jurisdiction and when you read Article 129 of the Constitution, it provides two very important expressions. First, power to punish for the contempt of itself. And second, court of record. So let's read Article 129 and then we'll be seeing it in detail. It says Supreme Court shall be a court of record and shall have all the powers of such court, including the power to punish for contempt of itself. So first let's study what is the contempt jurisdiction of the Supreme Court. So before we delve into it, we must read entry 77 of Union List 7th schedule of the Constitution, which provides that the Constitution, organization, jurisdiction and power of the Supreme Court, including contempt of such court. So one thing is clear, that the Parliament has got the power to pass law which can govern the contempt proceedings of the Supreme Court also. Now in the light of this entry, the Parliament has come up with the act which is called the Contempt of Courts Act 1971. When you read that act, section 23 of the Contempt of Court Act provides that Supreme Court has a power to make rules for its own contempt. Now in the light of section 23 of the Contempt of Court Act 1971 and article 145 of the Constitution, Supreme Court has brought a rule which is known as Rules to Regulate Proceedings for Contempt of the Supreme Court 1975. And when you read these rules, there are two very important rules which you must understand. First is Part 1, Rule 2. Rule 2 basically focuses on the fact that when any hearing is going on before the Supreme Court and court finds out that the contempt has been committed, Supreme Court has a power to take action and punish the contemner then and there. That's why the word used is forthwith. So Supreme Court can immediately punish that person, though generally court does not immediately punish the person, court issues the notice. But certainly court has the power to punish then and there. Second is Part 2, which is Rule 3, which says that in case of contempt other than the contempt referred to in Rule 2. So the Rule 2 was basically on the fact when the hearing is going on before the Supreme Court. Rule 3 is for the fact when the hearing is not going on before the Supreme Court, but still court finds out that there may be a contempt. So court in that time can take a suo motu action against the contemner. Second, the contempt action can also be taken by the petition of Attorney General or Solicitor General of India. And third, even a third party or individual person can file a contempt petition, but if it's a criminal contempt, permission of or the consent of the Attorney General or Solicitor General of India in writing has to be taken. Now coming to one very important judgment, which is Bhushan Power and Steel Limited versus Rajesh Verma 2014 volume 5 SCC page number 551. This judgment held that the contempt proceedings are between the court and contemner, and in the contempt proceedings intervention applications are not maintainable. So if the question is asked by any chance that whether intervention application is maintainable in the contempt proceedings, you have to cite this particular judgment that intervention application is not maintainable. Coming to the court of record, generally when this question is asked to the people that what is court of record, the answer people give that court of record is that court which has the power to punish for the contempt of itself. Certainly, if any court is a court of record, automatically there is an inherent power to punish for the contempt of itself. For example, even the High Court under Article 215 has the power to punish for the contempt of itself. But what is the meaning of court of record? So court of record is actually that court which maintains its record for perpetual period of time. For example, the plaint which was filed under Article 131 in 1975 or 1977, the party can get that particular plaint. Party can get the petition filed in the Supreme Court which were filed in 1975 and 1980 because the Supreme Court has been maintaining those records. So that is why it is called the court of record. And those petitions, those plaints which has been taken from the record of the Supreme Court or from the record of the High Court, they cannot be questioned. Their evidentiary value cannot be questioned. And it was laid down in the case of SCBA versus Union of India in 1998. So if you look at Supreme Court Rules Order 56, that is divided in two parts, Part 1 and Part 2. In Part 1, you will find those documents are there which Supreme Court maintains for perpetual period of time. For example, the petition, plaint, etc. And in Part 2, those documents are there which Supreme Court maintains for limited period of time, those records of the case. For example, the Wakalatnama or affidavit. Because that will be maintained by the Supreme Court for 1 year, the time period is given in front of that. So that is called the court of record. In any case, if any court is a court of record, it has the power to punish for the contempt of itself. So this is today's video. In my next video, I will be covering the original jurisdiction of the Supreme Court. So see you there. Thank you.